History as it happens, July 5th, 2022. The right to privacy.
In a landmark ruling, the Supreme Court today legalized abortion.
Robert Bork's America is a land in which women would be forced into back alley abortions.
The judge's responsibility is to discern how the framers' values, defined in the context of the world they knew, apply in the world we know.
Roe versus Wade and Casey have been overruled.
It says Roe versus Wade is history.
Today, the Supreme Court of the United States expressly took away the constitutional right from the American people that it had already recognized.
The demise of Roe versus Wade has left abortion rights supporters in a state of despair because they argue the government may now intervene in a private matter, a woman's pregnancy. The ruling is reigniting the debate over one of the most controversial legal questions. Is there an implied right to privacy in the Constitution? And if not, then what? Let's ask Akhil Amar next as we report History as It Happens, a podcast from the Washington Times. I'm Martin DeCaro.
Do I have this day an opinion, a personal opinion, on the outcome in Roe versus Wade? And my answer to you is that I do not.
Well, if that would happen, because I am pro-life and I will be appointing pro-life judges, I would think that that will go back to the individual states.
Senator, I said that it's settled as a precedent of the Supreme Court entitled to respect under principles of stare decisis.
Roe is not a super precedent because calls for its overruling have never ceased, but that doesn't mean that Roe should be overruled.
And it says something like the following. This is a very close paraphrase. That Roe versus Wade is not just bad constitutional law, it's actually not constitutional law at all, and it makes almost no pretense of being so because it doesn't connect its edict to kind of anything in the constitutional text.
If you have spent any time on social media, you may have noticed a lot of people were in no mood to celebrate Independence Day. That's because, as they see it, the Supreme Court is making the United States less free by ending the constitutional right to an abortion, among other major rulings that affect what we all agree are issues of enormous importance to American life. You know, the ruling overturning Roe versus Wade made me think of Robert Bork, Reagan's Supreme Court nominee who was rejected by the Senate in 1987 because his views were deemed outside the mainstream. And it was because of what happened to Bork that all nominees since try to avoid saying anything controversial about Roe or any case they may have to rule on, turning the confirmation hearings into a charade of sorts. Bork did not believe the Constitution contained a right to privacy, but it's worth listening to his response when he was asked whether Roe versus Wade was protected by stare decisis, the doctrine that courts will adhere to precedent.
I think it has to be, in the first place, clear that the prior decision was erroneous. I mean, not just shaky, but really wrong in terms of constitutional theory, constitutional principle. But that is not sufficient to overrule. I think I've discussed these factors before, but I'll mention them again. And a number of factors counsel against overruling. For example, the development of private expectations on the part of the citizenry. Is this an internalized belief in a right? The growth of institutions, governmental institutions, private institutions around a ruling. Now, I've given two examples of that. One was the Commerce Clause, one was the Free Press Clause, in both of which cases many institutions have grown up in dependence upon that and they've become part of the fabric of our national life. The need for continuity and stability in the law, which is certainly always a factor to be weighed. And the need for predictability in legal doctrine. And I think the preservation of confidence in the court by not saying that this crowd just does whatever they feel like as the personnel changes. But, and the respect due to the judgment of predecessors on a legal issue if they have explained their judgment. Now, of course, against that is if it's wrong, and secondly, whether it is a dynamic force so that it continues to produce wrong and unfortunate decisions.
Basically, you would have to, under your thinking, look to the area of stare decisis in determining whether or not you think Roe versus Wade ought to be reversed.
That is correct, Senator. I would have to ask myself what the presumption in favor of preserving a prior precedent meant in this case and whether it was overcome by other factors.
So again, that was Robert Bork in 1987 commenting on stare decisis, not specifically on Roe v. Wade and whether he would overrule it, although everyone knew what his position was. 35 years later, Robert Bork's views have been validated by the Supreme Court's conservative majority. And by overruling Roe, the court has ensured the abortion issue will no longer be the issue influencing the nomination process. Somewhat lost in the uproar, or elation, depending on which side you're on, was the legal reasoning, the legal history involved here. The long-running debate over whether the Constitution recognizes a right to privacy, and if so, where? And how did that implied right come to protect abortion in 1973? That is our focus here, the history of the right to privacy. We're going to pay less attention to the moral dimensions of abortion and the policy implications, because now that it's up to each state to decide for itself, that process is going to play out over the months, years, and decades ahead. Akhil Amar is Sterling Professor of Law and Political Science at Yale University, where he teaches constitutional law, and he is considered one of the top legal scholars in our country. He is the author of The Words That Made Us, America's Constitutional Conversations, 1760 to 1840, among many books on our founding documents. Akhil Amar, welcome back.
Thank you for having me, Martin.
This story is not entirely about constitutional scruples, and we'll get to this other point later on. I'm just going to mention it right now. It's also about a decades-long religious and political campaign, the Right to Life movement, whose goal is to end legal abortion. We'll get to that a little bit later. For now, the legal stuff. And I was wondering where to start with you. Maybe at the beginning, can one read the original Constitution as protecting privacy? For instance, the Fourth Amendment.
Absolutely. The Fourth Amendment protects certain elements of privacy. It, of course, says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Now, why are houses singled out above and beyond all other buildings? Factories, shops, warehouses. And I think the idea is that that's where private people live their lives. They don't live their lives typically in a factory or a barn or a warehouse. So it talks, just to go back to it, about the right of the people to be secure in their persons, houses, papers, and then everything else, effects. You can see a kind of proto-privacy principle in the Fourth Amendment. What kind of papers? Actually, private papers. And indeed, a reference to private papers appeared very famously in cases decided by the great Lord Camden in England, and the founders were very aware of Lord Camden. Camden was also a defender of the colonial cause, and that's why we see places like Camden, New Jersey, Camden, South Carolina, Camden, Maine. The Baltimore Orioles play in historic Camden yards. Camden, in some important cases in the 1760s, actually talked about private papers needing special protection. So you read the Fourth Amendment, persons, that's about my body, papers, especially private papers, like a diary, and houses where we live our private lives above and beyond all other buildings.
So what I hope to accomplish with these questions is to show how these ideas developed over time, why jurists who believe that there was a right to privacy in the Constitution started to point to, say, the Fourth Amendment or the Ninth Amendment or different aspects of the Constitution.
We could talk about the Third Amendment also, just because the word houses also appears in the Third Amendment. It's about no quartering of troops, once again, in houses. And the idea was, frankly, to protect a kind of a private space. Now, it was gendered back then. Part of the idea was that a man's house is his castle. That's called the castle doctrine. It's connected actually to certain ideas that some have linked even to the Second Amendment. The phrase "a man's house is his castle" comes from a Semaines case. It's a English case from the early 1600s, and in part it's about the ability to use deadly force in one's home to repel invaders. One gets to defend one's home space, and this man's house is his castle. It has a gendered feel to it. There was a gendered element to some degree of the Third Amendment. Part of the idea is that a man who controls his house and the people in his household, including his wife and his daughters, doesn't want another man, a soldier with a gun, in that space and challenging his control over his own castle, if you will. So the Second Amendment had antecedents in a home-centric vision. The Third Amendment explicitly mentions houses. The Fourth Amendment explicitly mentions houses in addition to papers and persons. And if you add all of that together, you can see a proto-privacy principle aborning.
I always thought that castle doctrine was Ralph Cramden, resident of Brooklyn, New York. The honeymooners.
I have images of his bellowing Alice.
Yes, that's right.
Floating through my head.
I am the king in my castle. The king, Norton. I rule my kingdom. Alice is just a mere peasant girl. Just a servant to do my bidding. I snap my fingers and she jumps. I'm the king of my castle.
Anyway, no time for levity here. So Louis Brandeis writes an essay in 1890 about common law tradition in the United States, protecting property in persons, and he says that principle is a fluid one, meaning as centuries of economic, social, political change take place. Our concept of personal privacy would also change. What's the significance of Brandeis' thinking in all of this?
He is an important figure in the narrative. He writes a famous article in the Harvard Law Review, co-authored, on the right of privacy, Brandeis and Warren, I believe. And he lineally descends from some of the history that I began to narrate. I mentioned Lord Camden in British cases. I didn't mention explicitly another pre-constitutional episode that was very important. It involved the writs of assistance. The writs of assistance controversy emerged in Boston in 1760 to 61, and it involved actually intrusive searches into people's homes, searches for smuggled goods. There's a direct line between that case that arose in Boston and Brandeis, because one of the people who was involved in that case, a man named Quincy, one of his descendants wrote up notes about that case that in turn was very relevant to a Boston-based jurist named Otis Gray, who would later be on the Supreme Court. So there's this direct line from Otis through John Adams and the Quincy family, and Gray, who is on the U.S. Supreme Court and is involved in a case called Boyd versus United States. And Brandeis is an heir to all of that and is writing about all of that in law reviews like the Harvard Law Review, this very famous right of privacy article, and in cases, a case, for example, called Olmsted that builds on a case called Boyd, and all of this actually, and Camden is cited. So there are these threads.
And I'm trying to maintain a chronology here, but it's hard not to bounce around. I did skip over, the 14th Amendment, right? You read the 14th Amendment, and it's not obvious as to how the 14th Amendment became one of the bases for Roe versus Wade, but the 14th Amendment is critical to this story, isn't it? It establishes equal protection under the law, citizenship, birthright citizenship, among other things.
So yes, the original Bill of Rights is a product of the American Revolution. The American Revolution involves locals against an imperial center. It's about Lexington and Concord and Bunker Hill, militias, for example, and you're going to see that in the Second Amendment. And the Minutemen, of course, are keeping guns in their homes, among other places. So that localist vision of the original amendment, what we call the Bill of Rights, has a very specific implication and lesson, which is these rights initially in what we call the Bill of Rights are declared against the federal government, against the new central government that's going to step into the shoes of the British imperial government that's been cast off. So the original Bill of Rights applies against the central government, the federal government. That's why the first word of our First Amendment is Congress. Congress shall make no law abridging freedom of speech and of the press, among other things. Now, later in American history, there's going to be another war, another constitutional war, the Civil War, and now the good guys are the central government, as the conventional narrative goes, and the bad guys are localities. And so the Bill of Rights is going to be flipped. The original Bill of Rights says Congress shall make no law, and it's about a set of rights against the federal government. The Fourth Amendment protects against the federal government, and the Third Amendment, federal troops, and all the other amendments. But after the Civil War, where the states have misbehaved, we're going to have, in effect, a new birth of freedom, a second Bill of Rights, and that second Bill of Rights is going to be limiting states and localities. And that's why it says, no state shall. It begins with a ringing affirmation of national citizenship, and then it says, no state shall. And of course, a case like Roe versus Wade is actually not about the federal government, it's about a state. Wade is the embodiment of Texas. It's about a Texas law. Or the Dobbs case that people are talking about, well, that's a Mississippi law. That's not the founding, it's the Reconstruction. The relevant text isn't a product of the Revolutionary War, but of the Civil War. And you can hear all of that if I just read you some of the relevant passages. Our First Amendment says, Congress shall make no law which shall abridge the freedom of speech or freedom of the press. Okay. Shall make no law abridge, but it limits the federal government. Now listen with fresh ears to the key language of the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Shall make no law abridge, the same words, but now the federalism dimension is being flipped. These are rights in a national constitution to be enforced by the national government, national courts, and Congress in Section 5 against states. Shall make no law abridge, but now instead of Congress shall make no law, this amendment actually ends with words Congress shall have power. And it begins with national citizenship. And early on, it's proclaiming rights against states, using those same words, shall make no law abridge.
You know, I'm thinking of Ruth Bader Ginsburg right now because she was a critic of the legal reasoning behind Roe. Looking at the 14th Amendment, she thought the Due Process Clause was not the right way to go. It was more a matter, in her view, of equal protection under the law. What can you tell us about that?
That she has a point. The Due Process Clause is about fair procedures, and that's not really people's objection to abortion laws, because abortion laws are enforced through judges and juries and courtrooms in the usual way. You're already starting, Martin, to move toward, I hear abortion and therefore Roe and the Dobbs case, but I do want to mention something else that was in the news last week and connect it to our conversation. There was a case all about guns in New York City, a case called the Bruin Case. And why am I mentioning that? Because Clarence Thomas went out of his way in that case to say, if we're going to do history, we have to think not just about the founding, but the Reconstruction. We have to think about, for example, not merely arms, a vision of guns at the founding, but a vision of guns during the Reconstruction era. And he actually cites my work for that proposition. I'm cited in the Dobbs case as well, but he cites a book that I wrote called The Bill of Rights, Creation and Reconstruction. And what we've already begun to talk about is how rights in America are the product not just of the creation of the founding era, but of the Reconstruction era as well. Now, I talked about the federalism dimension of that. It's limiting states. Justice Ginsburg is talking about another dimension. That's an amendment that's very much about equality, a theme that Thomas Jefferson may have articulated in the Declaration of Independence, but he didn't quite mean it the way we mean it today because he's a slaveholder, you see, and the Reconstruction amendments are all about smashing slavery and affirming black equality, and Justice Ginsburg and I would say, and female equality as well. It doesn't say race in the 14th Amendment. 15th Amendment does. So I think it's about equality more generally, beyond racial equality. What's the idea? The first sentence of the 14th Amendment says everyone's born a citizen. Everyone born in the United States is a citizen. And what that means is everyone's born an equal citizen. We're all born equal. We're all created equal. But it's a different and deeper understanding than when Jefferson articulated an earlier version of this in the Declaration of Independence, and when various states talked about people being born free and equal. What does it mean to be born equal? Well, it's a deep Enlightenment idea to be born equal. Here's what I think it means. I think it means you're born equal whether you're born black or white. So it captures the racial issue. But it also means you're born equal whether you're born male or female, whether you're born, I would say, gay or straight, whether you're born in wedlock or out of wedlock, as was Alexander Hamilton, whether you're born first in your family or fifth in your family. There shouldn't be extra legal protection for firstborn folks, as there were special protections in Britain and in early America, primogeniture and entail laws. You're born equal whether your parents are citizens or whether your parents are not citizens. When I'm born in Ann Arbor, Michigan, again, my parents are not citizens. They're just medical students here. But I'm born equal to everyone else who was born in Ann Arbor, Michigan. It's a very deep idea, this birth equality idea. Justice Ginsburg never phrased it that way. I'm giving you my formulation of the thought. So now we're talking, just to wrap things up, about federalism issues. Originally at the founding, it's rights against the central government, and really only against the central government. And the 14th Amendment is about no state shall, and giving power to the federal government. Congress shall have power rather than Congress shall make no law. That's the federalism stuff. But also we have a different and slightly deeper version, or much deeper version, of rights warning, rights against states, and especially rights of equality.
As far as a right to privacy goes, it's certainly not express in the 14th Amendment. It's implied, right?
So the framers of the 14th Amendment are also building on state constitutions that say that all persons are born free and equal. And the language of the Civil Rights Act of 1866, that's the companion to the 14th Amendment, talks about what citizenship involves. If you're born a citizen and you're born free and equal, is that you're entitled to the full and equal benefit of all sorts of civil rights. And one of those civil rights, or a cluster of those civil rights, are connected to a concept that we might call privacy.
So we don't actually see those words show up in a SCOTUS opinion until, well, you can correct me if I'm wrong, 1928 Olmstead versus the United States, when Brandeis is now on the court. So this is 38 years after he wrote that article in 1890. He pens a dissent in that case, talking about a right to privacy, right?
Yeah, I can't confirm that that's the first time, but that's what I've always thought. Yes. And I'm sure you could do a computer search, but it's conventional to basically say Olmstead is a very important case in this line of jurisprudence. And I think we mentioned it earlier when we were talking about the writs of assistance, to a case called Boyd in the 1880s, to his dissent in Olmstead.
He talks about the right to be let alone. I mean, the case involved the Fourth and Fifth Amendments.
Yeah, it involved what we would call surveillance, a kind of wiretapping of the home.
And then in 1961, we have Poe versus Ullman. What is the significance of Justice Harlan's dissent in that case?
This is a case that arose in my backyard, so to speak. It arose in New Haven. It involved a Connecticut law that prohibited the use of contraception, even in a marital bedroom. It's going to come back to the Supreme Court in a few years in a case that is world famous, Griswold versus Connecticut. It was litigated, these cases, by Yale law professors. Since you mentioned Poe versus Ullman, Ullman was the town clerk of New Haven, and I say it kind of arose almost literally in my backyard because Andy Ullman was actually my next door neighbor. He was the son of the former town clerk, a graduate of Yale College, I think in 1961, and Yale Law School in 64, and a wonderful next door neighbor. So Harlan's opinion in Poe versus Ullman says, gee, Connecticut has gone too far, judged by a kind of traditionalism. The only state in America that apparently ever has tried to make it illegal to use contraception in one's home, even as between married spouses, husband and wife. And he says, in a nutshell, that's un-American. The rest of the court doesn't really engage the issue because they say, oh, well, Connecticut isn't really enforcing this law very vigorously, so we don't need to get involved. But later on, Connecticut actually enforces the law with a little bit more vigor, and that's going to lead to the Griswold versus Connecticut case, where Harlan will write a separate opinion, basically reprising his remarks in Poe versus Ullman, which I believe is 1961.
That's right. So 1965, the Griswold case. It's a famous case. It's the first time the Supreme Court, in a majority opinion, recognizes the right to privacy. So we've covered a couple hundred years in short order here of American history, trying to just give our listeners an idea of how this idea of a right to privacy develops in the law. So then 1973, and we have Roe versus Wade, which says that right to privacy, implied, also covers abortion. And you wrote recently an essay in a major publication saying, well, the court got it wrong in 1973. Whatever you think of abortion, the court was wrong. And I guess that's what Clarence Thomas, Alito, and the others are saying today, what Robert Bork said in the 1980s.
And not just Bork, but famous liberal law professors, many of whom, like me, were pro-choice. I would say the most significant scholar, arguably, of the late 20th century. He wrote the book that sold more copies than any other general book on constitutional law. It was named John Hart Ely. He clerked for Earl Warren, taught at Yale Law School, and then at Harvard Law School, and then at Stanford Law School, where he was actually the dean. His book, Democracy and Distrust, is actually dedicated to Earl Warren, and the dedication is to Earl Warren, you don't need many heroes if you choose carefully. So John Ely was a liberal. John Ely was pro-choice. But John Ely very famously wrote an article before actually the book Democracy and Distrust. It's in the Yale Law Journal. It's called The Wages of Crying Wolf. And it says something like the following. This is a very close paraphrase. That Roe versus Wade is not just bad constitutional law, it's actually not constitutional law at all, and it makes almost no pretense of being so because it doesn't connect its edict to kind of anything in the constitutional text. That article by John Ely is one of the 10 most cited articles of all time in the legal literature. Alito cites it, along with me and Archibald Cox, the great Watergate special prosecutor who was Saturday Night Massacred. History seems to be repeating itself in certain respects, but Alito cites prominent liberal commentators who have raised questions about Roe versus Wade. And these are many people who, as a policy matter, strongly identify as pro-choice, believers in women's reproductive rights, and think that they are the ones who should make these decisions, not government, which in my view is often sort of very crude and clumsy and ham-handed. That is government in all sorts of very complicated medical and moral and personal situations.
So does the court's decision here in the Dobbs case end the idea that the Constitution created a zone of privacy? That was the term that was used.
Yeah, let's just go back just a little bit. The zone of privacy language appeared in Douglas's opinion in the Griswold case, 1965. Douglas was a very smart fellow, but truthfully, he was careless. He was a genius, but he just did things very quickly, and he actually didn't care about constitutional text. He thought that was like baloney. He basically thought that reasoning was basically phony, and a quote famously attributed to him is, with 5 votes we can do anything. So he was much more breezy than Harlan. Harlan makes a traditionalist argument. He says, this is an un-American law because Connecticut is the only state that's ever done it this way. Douglas says, actually, there are these zones of privacy when you sort of look at various amendments. Now, the amendments that he pointed to, I think he took some liberties. He said, well, the First Amendment right of assembly. And I'm thinking, no, the First Amendment right of assembly is about crowds massing on the ellipse or...
That's right. There's no expectation of privacy when you're in public protesting, right?
or at Central Park or something. It's not about two people assembling on a bed. That's not really what the First Amendment right of the people to assemble was really all about. And he slid over too quickly. He mentioned the Third and Fourth Amendments, but he didn't really highlight the word houses the way I did and talked about home life. Harlan talked about that, actually, but Douglas, not so much. He breezed past that. He said, even the Fifth Amendment self-incrimination idea, that's about mental privacy. You mentioned earlier that Olmsted kind of talked about the Fourth and the Fifth Amendments. Well, the Fifth Amendment self-incrimination clause is actually not really about privacy, because with a proper grant of immunity, you can force people to talk about the most private and intimate things imaginable. And if you don't believe me, just ask Monica Lewinsky. The Fifth Amendment self-incrimination clause isn't really very plausibly a privacy idea, and the right of the people to assemble in the First Amendment, not so much. I think the Third, yes, it says houses. I think the Fourth, yes, it says houses, and it's about private papers and private persons. I connected even to certain precursors to the Second Amendment, the castle doctrine. A man's house is his castle, and he can use force to defend his house, his home. So Douglas talked about zones of privacy in Griswold. In Roe, Justice Blackmun tries to pick up on all of that. And just a personal note here, my brother clerked for Justice Blackmun later on after Roe versus Wade, but I don't think Justice Blackmun, frankly, did a very good job of it. In one paragraph, here's what he says, and here I'm quoting. The Constitution does not explicitly mention any right of privacy. In a line of decisions, however, going back perhaps as far as 1891, the court has recognized that a right of personal privacy or guarantee of certain areas or zones of privacy does exist under the Constitution. And then he cites a whole bunch of cases, including one involving erotica in the bedroom. Today we would call that the internet or something, perhaps. It's called Stanley versus Georgia. From 1969. He does actually cite the Boyd case, which I briefly alluded to, from 1886, and the Brandeis dissent in Olmsted. He cites Griswold from 1965 and mentions the penumbras of the Bill of Rights and mentions some other things as well. Okay, so he cites a bunch of cases and some other cases that are relating to marriage, a case called Loving versus Virginia, contraception. And then he says, just after basically just simply citing them, not really telling you very much about them, and this is just kind of out of the blue, and it's just an ipsa dixit. It doesn't really have a lot of careful analysis to it. It's just announcing his bottom line. This right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or as the district court determined in the Ninth Amendment's reservations of right to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Now, here's a couple things about that key sentence. He doesn't seem that interested in where it actually comes from textually, whether it's in the 14th Amendment or the Ninth, whatever. And when he mentions the 14th Amendment, he just talks about the concept of personal liberty. He never, and he says that's actually where we think it is. He never in the entire opinion so much as quotes that language. And if you read that language, it actually isn't quite a concept of personal liberty. It says, actually, states can't deprive any person of life, liberty, or property, for that matter, without due process of law. But the flip side is presumably they can deprive people of life, liberty, or property with due process of law. It's really not a guarantee of liberty, a concept of liberty, any more than it's a guarantee of property, for that matter. It's a guarantee of due process, of fair procedures. The word process is very closely connected to the word procedures, and his objection to abortion laws isn't procedural. It isn't that they're not proper judges and juries applying the abortion laws. So he's doing a thing that lawyers call substantive due process, basically saying judges can strike down laws that limit life, liberty, or property if they don't like the substantive reasons behind those restrictions. But almost every law modifies, or many laws, life, liberty, or property broadly construed. And if judges get to decide for themselves whether the law is good enough, that's pretty sweeping. And it's not just liberty, it's property as well. And why am I mentioning all this? Because the granddaddy of substantive due process is called Dred Scott. Dred Scott said, Slaves are property. And when a state basically says you can't bring a slave onto our soil, and if you do, you will forfeit your property rights, the court in Dred Scott said, oh, that's a violation of due process. Even though the law had fair procedures, the court just didn't like the idea that a court could say you forfeit your property. That's actually where substantive due process comes from. It comes from Dred Scott, and it doesn't have such a great pedigree.
I was going to bring up substantive due process in my next question. I'm glad you raised it because Clarence Thomas, in this Dobbs case, brought up that issue. He said it's time to reassess some of the other cases the court has recently decided that involve substantive due process. Conservatives believe substantive due process is a nonsense that has to go.
John Ely said that in his book Democracy and Distrust, which, to repeat, sold more copies than any other book of its generation. It's a great book on constitutional law. John Ely, to repeat, was a preeminent liberal Warren Court clerk, and John Ely thought substantive due process was kind of an oxymoron. Substance is the opposite of process. He reminded his readers, as I've reminded your audience, that this case kind of has an awkward pedigree. It's implicated very powerfully in the Dred Scott case. So is a case called Lochner from the early 20th century, which sort of has come to exemplify an entire era, about a 50-year period between the 1880s and the early 1930s, when courts are striking down all sorts of laws that limit economic rights, minimum wage laws, maximum hour laws, and the like, in the name of substantive due process. Now, there they were protecting property, and maybe in Roe or Griswold we're talking about liberty rather than property, but there is this problem that liberty and property, for that matter, are protected in the text, at least this text, only with a promise of fair courtroom procedure.
So this now raises the question in the minds of many Americans, maybe younger Americans especially, who've grown up only in a post-Roe world, who maybe thought that, well, of course the Constitution, federal rights, protect bodily autonomy. These people may argue, whether one agrees with them or not, that we live in a country now, if the right to an abortion is not protected by the Constitution, then I don't have a right to bodily autonomy. And if I'm in Texas, I don't have that right, but if I move to California, I do. We create a patchwork of rights. How would you approach that argument?
So first, I want to go back to Roe versus Wade. I told you that they cited a bunch of cases and then just didn't discuss them at all, including Griswold and the Olmsted dissent and some other cases, and then just said, boom, that right, wherever it comes from, parenthesis, who cares, close parenthesis. That's how it felt to many readers. Wherever it comes from is broad enough to encompass a right to abortion. They just said it full stop, and there had never been a previous abortion case ever. It's the Supreme Court. First case, and they just sort of announced it. But then, a few pages later, here's what they say. So they say privacy, because there were cases about privacy, and then they said that's broad enough to encompass abortion. Here's now what they say like 2 pages later. This is Justice Blackmun's opinion. Quote, "The pregnant woman cannot be isolated in her privacy. She carries an embryo, and later a fetus if one accepts the medical definition of the developing young in the human uterus. The situation is therefore inherently different from marital intimacy or bedroom possession of obscene material or marriage or procreation or education, which Eisenstadt, Griswold, Stanley, Loving, Skinner, Pierce, and Myers were respectively concerned." So they had string-cited these earlier cases. And they said they're broad enough to protect abortion. And then 3 pages later, they're all inherently different because they don't involve the fetus, this unconsenting entity. And when I first read this, my first semester of law school, I thought, I'm not cut out for this because I just don't get it. I'm confused. You cite these cases, you say they're broad enough to encompass abortion under an idea of privacy, and then 2 pages later you tell me, no, abortion is inherently different because there's a fetus involved. Well, truthfully, that wasn't my confusion. That was Justice Blackmun's confusion, and that's what the court is saying in Dobbs. So one thing that they're saying is There are lots of other cases, and we don't actually intrude upon them, especially true privacy cases, because this is different and involves another entity, innocent unborn human life, in a way that, for example, contraception doesn't, or interracial marriage doesn't, or a bedroom possession of obscene materials doesn't. So one thing that they say is, gee, if it's really about privacy, this is different. I'll say it a different way. It's not taking place in a house or home. An abortion isn't, at least when you're going to a medical care provider outside your home. So let's go back to Griswold. It's about two people. Maybe they're married. In fact, in Griswold, they were using contraception in their marital bedroom. Okay, so they have a deep relationship. It's their home. It's their bedroom. And there's no life in being or something there.
And that law wasn't being enforced either, right?
Oh, it was in Griswold. Okay. It wasn't in Poe versus Ullman. Okay. And so the Griswold case actually arose because Connecticut stupidly started enforcing this law, which had been on the books. And that prompted the Griswold case. And now let's contrast that with the typical abortion situation. Now, pills might be different, pharmaceutical abortion, but where you're not in your home, you're interacting with someone you've maybe never met before, a healthcare provider, may never meet again. Money is changing hands. It's not in a house. And there's a fetus involved. So that's why privacy is an awkward way of talking about all this. And you know who understood that immediately is Ruth Bader Ginsburg, which is why she said, actually, it's not so much privacy, it's women's equality. Yeah, that's a different argument than privacy in the home, don't you see?
I brought her up before for that reason.
A second point is the court itself says, here's another really limiting principle of our decision. We are actually focusing on what states in fact do and what rights basically are part of the American experience. Remember I said before that Justice Harlan in Poe versus Ullman, in a language that he's in effect going to point to, incorporate in Griswold versus Connecticut 1965, says the law of Connecticut is almost literally un-American. Connecticut is the only state in America that doesn't let spouses in their homes have sexual intimacy. Roe is the exact opposite of that. And remember, this is the first abortion case to ever reach the Supreme Court. It admits that everything else that's ever done before is inherently different. But in the first case, they come up with these sweeping regulations of abortion about trimesters and viability, all sorts of stuff that invalidate the laws of at least 49, maybe all 50 states. The only state possibly that was compliant with Roe at that moment, 1973, given all of Roe's new rules, was maybe New York. So this is emphasized strongly in the Dobbs majority opinion. Maybe there are unenumerated rights. We are not foreclosing that idea at all. Indeed, it cites cases that recognize unenumerated rights. But where do we find them? We find them in American custom, American practice, American mores, and how do we best actually measure those? By looking at actual state practice. So just to recap the bidding. Griswold, easy because only one state ever tried to restrict this right of marital privacy. Roe actually easy the other way and wrongly decided because it's invalidating the laws of 49 or 50 states.
Yeah.
Now, if that's the test, all sorts of things that we've come to take for granted, don't worry about, not just because they don't involve a fetus, which the court in Dobbs emphasizes, but also because they're just part of the furniture of modern American life. And they're unlikely to be threatened by a whole bunch of states. Maybe one weird outlier state might pass this weird law or that one. Maybe it's Oklahoma on this law, or Missouri on that law, or Arkansas on some other law. But unless you get a whole bunch of states basically saying you can't use contraception, or you can't marry someone of a different race or something, unless there were a whole bunch of states doing that, the Harlan analysis, the traditionalist analysis, the state counting analysis, the Dobbs analysis, and they build on a case called Glucksberg, would protect these unenumerated rights. Oh, and one final thing, since I mentioned interracial marriage. Interracial marriage is rooted not just in unenumerated rights, like the right to marry the person that you love, but in a deeply enumerated, textually specified right, namely a right of racial equality. interracial marriage is rock solid easy, both because it's a traditional American practice, very deeply rooted in existing state practice, and also strongly rooted in the expressly textual idea of equality.
So this is where public opinion, in a sense, does play a part here. And
it does, but note asymmetrically. Here's what I'm saying. I'm not saying public opinion can, in effect, cause a textually enumerated right to disappear. No, if something's in the Constitution, damn it. If a right is in the Constitution, we protect that right come hell or high water. It's in there, and if you don't like it, amend the Constitution. That's what I say about racial equality or sex equality or sexual orientation equality, because remember, I think the first sentence of the 14th Amendment stands for birth equality. We're all born equal, whether we're born black or white, male or female, Jew or Gentile, gay or straight.
All persons, regardless of the things you can't control about yourself.
That's the birth equality idea. So these equality rights are really deeply rooted in constitutional text and history. And when it comes to things like interracial marriage or contraception, they're also very, very well established in American custom, practice, tradition, consensus, as measured not so much by polls, but by laws on the books, but asymmetrically.
Well, I was going to say, though, abortion doesn't fall into that category because it's been controversial.
Exactly. But I did want to say on paying attention to American understandings, it's asymmetric in that if a right is in the Constitution, we enforce it until the Constitution is amended. If it's not in the Constitution, we still might enforce it because it says in the Ninth Amendment there are unenumerated rights. It says no state shall make or enforce any law which shall abridge the privileges or immunities of the United States without comprehensively itemizing it. It doesn't just say, important rights mentioned in the Constitution. It says all privileges and immunities, all fundamental things. And the point is, how do we find those unenumerated fundamental things above and beyond the things that are textually specified? Speech, press, petition, free exercise, and so on, by looking at actual widespread American practice. And that's what the Dobbs decision, in fact, says.
So, Akhil Amar, I want to return to originalism now. I'm always puzzled when I hear someone, especially a Supreme Court justice, say, well, this word, this thing is not in the Constitution, so that's that. You can make a really strong argument, as you've done right here, that Roe versus Wade was bad law and a bad decision that needed to be thrown out, without resorting to what I would expect someone on a cable news panel to say. Well, abortion's not in the Constitution, so that's that. What do you feel about that?
That would never be that, but it would be the first step, because if it is in the Constitution, you got to protect it. If it's not mentioned, then there's this second level of analysis, because the Constitution talks about unenumerated rights.
The Ninth Amendment.
And even when it comes to states, it doesn't specify, doesn't enumerate textually all the privileges and immunities of citizens that no state shall abridge. It presumes that they're out there, but it doesn't quite list them all. And I think the majority in Dobbs gives us a framework for how you find them. You find, in effect, these fundamental rights, what I've been calling privileges and immunities, because I prefer to use that language rather than the language of substantive due process for reasons we've discussed. Where do these privileges and immunities of citizens that no state shall abridge, but that aren't textually itemized, where do they come from? I think they come from America, from actual citizen practice and lived experience as measured by broad consensus of state laws. So it doesn't say contraception, that's true, anymore than it says abortion, but Griswold is easy and obvious because in every state except Connecticut, it is a privilege and immunity of American liberty to, in your own home, be able to have marital intimacy with your spouse. It's a basic privilege and immunity of citizens. Where did I get that? I didn't make it up. I actually looked at actual American practice, and Griswold is easy, and that's what Harlan says. Now, Roe says abortion isn't mentioned in the Constitution, but what's the method for finding it? Well, Roe doesn't pay much attention to actual state practice and, in fact, invalidates the laws of every single state, or maybe every single state except New York. Well, that's a very problematic way of cashing out this idea of unenumerated rights of Americans by not paying attention to what actually is the lived experience of Americans and the consensus of America.
And privileges and immunities, that is mentioned in the section of the Constitution that deals with the relationships between the states. Correct.
Well, it's mentioned twice in the Constitution. First, you're right in Article 4, but then again it's repeated in the 14th Amendment, you see. Right. And in the 14th Amendment context, as I keep emphasizing, the key phrase is, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Again, now, what are those? Here's the base point. If it's mentioned in the Bill of Rights, that's pretty good evidence it's fundamental. No state shall make or enforce any law which shall abridge speech, press, petition, free exercise, assembly, right of against unreasonable searches and seizures, double jeopardy, fair trials, public trials, jury trials. Okay, all of that. But if they only meant rights already mentioned in the Constitution, no state can make or enforce any law that shall abridge rights mentioned elsewhere in the Constitution, they could have said that pretty clearly. So I think they meant more than that, or put differently, I think they meant to say no state can mess with, in effect, Ninth Amendment rights any more than it can mess with, say, First or Second or Third or Fourth Amendment rights. And Ninth Amendment says, there are all these unenumerated rights. Again, how do we find them? Both against the federal government, Ninth Amendment, and against states, 14th Amendment, by looking to actual state practice. And Dobbs says that emphatically.
So I want to return in my final question to you to the point I made at the very beginning of this conversation about that this involves more than constitutional scruples. There has been a decades-long campaign, the Right to Life movement, to end legal abortion. And people, mostly on the left of the political spectrum, but maybe even some more moderate or centrist American voters, they're looking at the Dobbs case. They're looking at the ruling on guns. They're looking at the ruling on school prayer. And from their perspective, maybe not the perspective of the editors of the National Review, but from their perspective, they say, if this is what the Constitution says, then I don't really like the direction my country's going in.
One of the most fundamental rights that exists is the right of the people to amend the document. If you don't like something that's in there, you can amend it out.
It's very difficult
to do, though. Every generation has that right.
I mean, it happened in, the 1990s, there was an amendment, but prior to that, I think you have to go back to the 70s and the 60s. Of course, you're right, but they would say, we're not going to amend the Constitution in this political climate.
They would say that because, you see, they don't want to admit that not all of their fellow Americans agree with them. And here's what I'm trying to say, actually. If you can show me it's in the Constitution, you win. And if you can show me it's not explicitly in the Constitution, but it's implicitly in the Constitution actually, because it says they're unenumerated rights, you also win. But if it's not in the Constitution, then you can often protect something by a statute, and when enough states do that, that becomes a fundamental right. Okay? If there's a right that is in there that you don't like, you can amend it out, but it was hard to put it in the Constitution, and it should be hard to take it out of the Constitution. So I'll say them 2 or 3 things. One, it's not just about you, it's about us. And here's actually how we have to come together, by actually paying attention to what the Constitution says and the history behind it. And if you're not interested in that, I'm sorry, but you're paying attention to baseball and football and basketball and hockey, and you have to pay attention to this too, because this is about all of us together. And that's what this podcast is, of course, about, and my books are all about. So if you want to be an American, you have to join the American Project and be part of this conversation. And part of it is knowing what the Constitution says and paying attention to the history. And then if you don't like it, you can rise up and amend it, as have many generations before you done so. The original Constitution, when it's proposed, people in the ratification process say, dudes, you forgot the rights. And immediately there are a whole bunch of amendments added. We call those the Bill of Rights. And then there weren't amendments for a long time, and the system actually became very corrupt in various ways, dominated by a slaveocracy. And people eventually rose up and added 3 glorious amendments, the 13th, 14th, and 15th Amendments, which we've talked about a bit today. But that left women out of the equation to an important extent, and a half century later, people rose up again and added a whole bunch of new amendments to the Constitution, including the woman suffrage amendment. And then there was another half century where the whole cluster of amendments, a spurt. There was another half century where not so much. And then in my lifetime, in the early 60s, yet another glorious cluster of amendments. And we could do it again today. My fellow Americans, now, I actually think that there is already an ERA in the Constitution. I think the equality language of the 14th Amendment is all about women's equality as well as black equality. I'm with RBG on that. But I think we should say it again once more with feeling. Let's do that now. Let's do our ERA from scratch right now. Let's have a great national coalition to do that. There are things maybe that lots of Americans agree on, but you're going to have to join the rest of us in a constitutional conversation. So I don't buy the argument that, oh, you can't do it.
Well, there's also...
It's been done again and again and again. Now, if our fellow Americans don't agree with us, that's a different problem.
Well, I would say there's also the political process as well. And now that I'm in my mid-40s, I do often find myself talking to younger people who are, to hell with politics, to hell with these two parties, and I say to them...
And I say, with all due respect, to hell with them, because I'm tired of their just, complaining and get off my lawn, okay? Because what's actually your choice?
Well, yeah, let me finish my point. I mean, right now the abortion issue returns to the democratic process, and
so you have to vote.
Yes,
and you really do.
And if the polls are correct, they show that most people, again, depending on which state.
Well, you're setting me off now.
No, but let me finish my point.
No.
I need to finish my point, and then you can have the final word. Most Americans do not want abortion banned entirely. Now, there might be exceptions to that depending on region, but if that's the case, then Democrats have a winning issue in most states.
In some states. You really buried the lead when you said,
But it could change, though, in the other places. If it turns out that abortion bans lead to disaster, as some liberals are predicting, then in those places people can make an argument in the political arena as to why those laws should be repealed.
So what I would say is you have to vote. We make laws not by polls, and so you have to vote. And the polls can be highly misleading because they don't capture intensity of preference, they don't capture likelihood of voting, they don't capture whether something is a single issue for some folks or not, and they don't capture regional variation. Now, if we're talking now about the actual policy of abortion, I just want to share with my fellow Americans a few key points. First, that 80% of abortions occur in America in a few states where the Dobbs case will have no effect whatsoever except to actually encourage them to be even more open and affirming, especially of their fellow citizens from sister states who may need to travel to get needed services in their state. The key point is a right to travel, which Justice Kavanaugh went out of his way to say a state can't fence its women in. They have to be able to cross state lines to get medical procedures. So he was emphatic about that. None of the other justices in the majority said anything about that. He went out of his way to talk about that. Now you say, well, that's easy. If you're wealthy, what if you're indigent? It's very important to actually have funding for women in distress, and you don't need the Supreme Court's approval to do that. You can do that. Your private charitable donations.
Charities and state legislatures can provide funds.
Yeah. All these things, exactly right. Okay, so here's what I'm saying, because there's a lot of noise out there, and I'm saying you have to vote no matter what. But the reason isn't that actually same-sex marriage is really at risk or contraception is really at risk. No, that's not actually what's going on. Here's what's really at stake. If abortion were banned nationally rather than just by Mississippi or by Mississippi and Texas or by Mississippi and Texas and Arkansas or by Mississippi and Texas and Arkansas and Oklahoma, etc., but if it were banned nationally, that would be a totally different America. And it will, I predict, be banned nationally if the Republican Party, which has always been against Roe versus Wade, really for the last half century when you read their national platforms, It will be banned nationally if the Republicans control the House, the Senate, the presidency, and the Supreme Court, which they do already. They will get rid of the filibuster in 2025 if they capture the 2024 elections across the board. If they win House, Senate, presidency, they already control the judiciary. There will be a national ban on abortion. And then, that's a profoundly different America than the one we have even today after Dobbs, in which people can travel and poor people can be funded.
Akhil Amar, we thank you for your time and insights today. On the next episode of History as It Happens, we're going to build on some of our recent conversations about the war in Ukraine and the post-Cold War order, the so-called liberal international order run by the United States. We're going to search for patterns in history. That's next as we report History as It Happens, a podcast from the Washington Times.